go ahead and get started. Again, thanks for everyone for getting on the Zoom call. And like I said, it's a beautiful sunny day, and which is nice after all the rain last week, but it's good to be out. I've actually been in quarantine for a couple of days, so I'm glad to get out of my house and see people, even if it is virtual. So good morning. I am Laura Grimes. I am the Chief Financial Officer at the Conway Chamber of Commerce. I also serve in the role of our HR person, director, whatever that may be. For any of you who serve in that capacity, you know that has its challenges. So I'm really interested in this session. So this will be the third installment of our virtual business series. We would like to thank Walmart and Sam's Club for sponsoring the series, which enables our attendees to tune in at no cost. So thank you to Walmart and Sam's Club. Today we are going to look at the topic of human resources and COVID compliance, which is all on our minds each and every day right now. So with us today, presenting on the subject is Mr. Jim Gary of Kutak Rock. His practice focuses solely on employment litigation and traditional management labor relations on behalf of employers across the nation. So we thank you, Mr. Gary, for being here with us. For those of you in attendance, if you have any questions throughout the presentation, I invite you to post those in the chat feature, and we will get to those as time allows. So Jim, I'll turn it over to you. Thank you again for being with us.
All right, thank you. Can everyone hear me? Can you hear me okay? Okay, and is the PowerPoint up? All right, she's thumbs up. Well, thanks for inviting me. There's a very large PowerPoint that we're not going to be able to get through today. It's 100 pages long, but it contains a lot of, I think, valuable information. I advise employers every day on many issues, and beginning in March, more COVID than I ever thought I would. So if you would like a copy of the PowerPoint, I think we've decided if you just want to reach out to the chamber there in Conway, they'll send you one. By the way, I love Conway. I have several clients up there, and it's a delightful place. The other thing is we're not going to get through everything today, and that's why I urge you to request a PowerPoint. It's free, and you don't get free legal advice very often. Let me see if I can work this. In the PowerPoint, you don't always have to call a lawyer. The various government agencies, EEOC, FLSA, CDC, those federal agencies have done a really good job of putting information, posting information on their websites, and a lot of it is broken down into questions and answers. So if you don't want to call a lawyer, you don't need to all the time. Just go on some of these websites that are in the PowerPoint, and you'll find a lot of information that'll help walk you through various questions. What I've done today is I've broken this presentation down into two tranches. The first is furloughs, layoffs, and RIFs. And I honestly believe that furloughs, layoffs, and RIFs will hit our economy again in the not too distant future. We went through a lot of these in March, but I think that we're going to see them again. So I'm going to spend some time on that first tranche. And the reason is because I see this as the largest, I see this to potentially be a large threat to employers in terms of expensive litigation. So I've got steps in here on how to plan and implement these RIFs. And then the second is a kitchen full of reopening and operating safely issues that you probably see on a daily basis if you're in human resources or you work with human resources. And if we don't get through all of that, just look at the PowerPoint. So let's talk first of all about furloughs. I'm getting a lot of questions about employee furloughs, and I've been practicing labor and employment law for 40 years. And frankly, I don't think I'd ever heard the word furlough before March of 2020. I mean, I had heard of it, but not in the legal context. So again, a lot of questions from folks that, well, you know, we know what a layoff is and we know what a reduction in force is, but what do we do about these furloughs? Well, the law really doesn't define what a furlough is, but generally it is separate and distinct from a permanent layoff or a reduction in force. And these are situations that we see in COVID where an employee or temporarily mandates leaves of absence, which most of the time it is expected that the employee will return to work. And a lot of the questions I'm getting is, well, we've got people on furlough. What are they entitled to in terms of benefits? And determining upon what the conditions of the furlough is, then in most instances, unless your policies or practices vary, there's a lot of latitude in what benefits continue and which aren't. So, and we'll cover that. Okay. While an employee is on furlough, generally speaking, he or she is still considered to be an employee. They're just not working. Now, you don't have to follow that. You don't have to implement a furlough program. You can implement a permanent layoff. What we're seeing a lot of is temporary furloughs evolving into permanent layoffs. But if an employee is on furlough with the expectation of being recalled, then remember that all the labor and employment laws apply to him or her, just like if they were coming to work every day. That is unlike a reduction in force where the employment relationship ceases. So all the just anti-discrimination and Fair Labor Standards Act, workers' compensation, all that's still going to apply to this furloughed employee. Getting questions about exempt employees. These are salaried exempt employees. Getting questions about the docking rules under the FLSA. So if you have a salaried employee and he is on furlough or on a reduced schedule, the question is, can you dock him? The answer is, there are some exceptions to this, but by nature of the exemption, he is guaranteed a predetermined salary for a work week, and you cannot dock him for partial days that he or she doesn't work. So if he doesn't work an entire week, then he doesn't get his salary. If he performs any work during a week, then he's entitled to his full salary. Can the salary be reduced? Yes, the salary can be reduced during a furlough, as so long as it's done on a prospective basis. You tell the salaried exempt employee that his salary is going to be reduced, but you still have to meet the salary basis test under the FLSA, or you'll lose the exemption. Can you ask exempt employees to perform non-exempt duties during a furlough and not lose the exemption? The answer is yes. a exempt employee may temporarily perform non-exempt duties that are required by COVID under the public health emergency without losing the exemption, again, as long as they are paid the salary basis. Non-exempt employees that are coming to work, they're not totally furloughed, they're partially furloughed. They come to work 2 days a week. You only have to pay them for hours worked, unlike the salaried exempt. You can reduce their hourly rate if due to the economics of COVID and budgetary constraints. You can reduce their hourly rate for time worked, so long as you don't reduce it below minimum wage, and so long as there's some contractual obligation not to do that. Workers' compensation. The governor issued an executive order. This doesn't necessarily apply to furlough employees, but I put it in here in June that says basically that employees who contact COVID in his or her employment, that is covered. They are covered under workers' compensation. It's considered an occupational disease. Benefits issues. A lot of questions about benefit issues for furloughed employees. What do we do about their health insurance? What do we do about their paid time off? What do we do about their vacation time, et cetera, et cetera? In terms of healthcare in particularly, it's important to look at your plans to determine if there is an actively at work requirement to determine if you can even continue certain benefits. Many healthcare plans require this. If a person's not actively at work, then they're not covered under the policy any longer. Can an employer reduce PTO, vacation, personal days? Yes. Again, subject to your policy and plans and any contractual obligations, you can reduce or eliminate this while an employee is on furlough, so long as there's not a contractual basis for the employee to argue that he or she is entitled to that, or a statutory basis. So the general rule is an employer can require a furloughed employee to take leave during a furlough, or it can allow the employees to choose whether or not to use, for example, their paid time off. I'm kind of speeding through these. I'm going to go to a permanent layoff, which is different from a furlough. We're seeing that. And again, we're seeing furloughs turning into permanent layoffs or RIFs. I was familiar with a permanent layoff well before March of this year. It is considered to be a final separation of the employment relationship. You have to be careful in how you characterize these and design these as to whether or not they're permanent layoffs or temporary layoffs. And we're going to get into implementing a layoff plan. And you also have to be careful in, if you have a layoff, in deciding whether or not you want assurances of recall at some point in the future. A RIF, everyone's familiar with a RIF. A RIF is like in my mind, a permanent layoff. It usually is broader in scale, and it's the elimination of positions. And again, we're seeing a lot of this during COVID. Now, I'm going to make a prediction here, and this is what I was getting to earlier, that there may be a widespread increase in litigation as a result of COVID-related RIFs, furloughs, and recalls or return to work. And why do I say this? Well, I say this for two reasons. One, I'm already seeing them, and we'll talk about that in a second. And two, to no fault of managers or supervisors, HR or senior level personnel will design a RIF program or a layoff program, but the managers don't understand it. And so the managers sometimes, or supervisors, will believe that a furlough, a RIF, is a good time to get rid of poor performers without going through the required steps. And we're seeing charges filed on this, and we'll get to that. All right, so if you believe, or if you don't believe, but you have to implement a permanent layoff or RIF, I've outlined 8 practical steps here in what you should do to plan and implement a RIF or a permanent layoff. Step 1 is, I think, is you need to decide is the layoff going to be voluntary or involuntary? There are advantages to voluntary RIFs because they can reduce the risk of selection and termination lawsuits. The disadvantages is you have no control over the number or who participates. And good employees may choose to take the voluntary reduction, and the poor performers may decide to stay. So step 1, decide if it's going to be voluntary or involuntary. Step 2, determine the scope. Is it going to be isolated to a department or an office or certain production lines? Is it going to be the entire company? And of course, comply with the laws, and we'll get into that. Again, this is the soft underbelly, as I say, that I see for potential lawsuits. The selection process. So you decided it's going to be voluntary or involuntary. You've determined the scope of the RIF. Here comes the most important thing, the selection process. Who's going to be RIFed? Who's going to be impacted by this? You have to ensure on the front end that all your actions and decisions are based on what the law considers to be objective, legitimate, and non-discriminatory factors, such as quantity or quality of work, rather than some protected characteristic, race, age, union animus, whistleblower status, that type of thing. So you need to decide this on the front end. What is your selection criteria? Is it going to be based on seniority? Is it going to be based on skill set? Is it going to be based on performance level or some other valid criteria? These are, now this applies both in the implementation of the layoff, but also in terms of the recall or the rehiring. Now, you decide what your selection process is going to be. You need to determine, you need to review it on the front end to determine if the process, if the criteria will result in a disproportionate dismissal of employees in a protected group. What do I mean by that? Here is an example. If female employees may be affected more than male employees, you should compare the percentages of females affected to the percentage of males. For example, you decide to lay off the most recently hired employees. That's seniority. That seems to be a safe harbor in terms of a reduction. for budget constraints, and females account for 30% of the workforce, but 85% of them are selected for layoff. That should send up a red flag. That arguably creates a disparate impact. You don't intend to discriminate against these female employees. You think you've used objective factors in seniority, but the impact, it has a greater impact on females. So you should consider adjusting the criteria that will allow you to still meet your goals, and maybe choose some other criteria such as productivity. Of course, when you get into productivity, you get into an issue of proving when somebody's a poor performer versus somebody who's not. So, oh boy, managers and supervisors. Managers and supervisors, and I'm mostly talking about frontline managers and supervisors, play a critical role in these reduction programs. It is critical that you make sure that they understand the criteria, they apply it accurately and consistently, and that they're accountable. So part of your implementation plan before you implement it is to make sure that the supervisors understand. They understand the importance of their role. You might consider giving them training, telling them what the do's and don'ts are, because they're going to be talking to rank and file employees more than the upper level managers are. And what they say or what they tell employees can bind the company. You might consider giving them talking points if they have questions about the reduction or the layoff. You need to tell them that if you don't understand or know the answer to the question, to direct the employee to HR or someone else who does. Very important, very important. This is where I think some of the litigation will arise out of. Step 5, the communication process. How are you going to communicate the reduction in force? What are you going to communicate? When, what, where, why, how, that type of thing. And that needs to be part of your planning process. Your communication process on the reduction needs to be carefully thought through. Why does it need to be carefully thought through? Because you're creating a record of the reasons and the factors that you considered when implementing a reduction. And what you are doing is you are creating admissible evidence in court. So on paper, you could have the best reduction permanent layoff plan in the world on paper, but if it's being communicated differently, then you've got some issues. Waivers and releases. Are you going to have waivers and releases as part of the reduction in force? You can. The materials contain information for how that should be done. Immigration issues. There are immigration issues with furloughing or laying off persons on H-1B, LE, and TN authorizations. You can go to the Immigration Service, U.S. Citizenship and Immigration Services, and find the information there. But there are monetary repercussions to you as the employer if you don't follow the steps. Advance notice. Your plan needs to determine, or your planning needs to determine, am I required to give advance notice of the layoff or the RIF? Technically, on a furlough, there's not an employment loss, but on a permanent layoff or RIF, there is, which might require you to give the 60 days WARN Act notice. There is no mini WARN Act requirement in Arkansas. The WARN Act is technical. It's hard to follow, but you need to look at it. There are some possible COVID-related exceptions to giving the 60-day notice but there are no absolute safe harbors. So in March, it seemed like to me every company in the country was closing, shuttering, laying people off. I don't know if that's going to occur in the future. So we started looking at exceptions to the 60 days notice. And there is a potential exception known as unforeseeable business circumstance. But you need to look at that real closely before you rely on it. All right, so that's reducing the workforce. The flip side of that coin is bringing employees back after the reduction. I think I've already covered this, and I set a timer to get to the other part. Okay, so you permanently lay off an employee and you haven't given them any assurances of recall, and you start ramping up again and they want to come back to work. Technically, a new employment relationship is formed. Now that could be subject to collective bargaining agreements and past practice. So the question becomes, when you're hiring former employees to come back to work, are the hiring requirements relaxed, or are you required to satisfy, or can you satisfy all the pre-hiring requirements if they had never worked for the company? Again, the selection process for recalling or rehiring laid off employees, it's essentially the same as for the decision to lay them off in the first place. Be careful of discrimination, disparate impact, disparate treatment, and retaliation. I'm going to say one more thing about this subject before I go on. I'm already getting employer EEOC charges on this very subject, and this is what caused me to connect the dots, because not everybody, but a lot of people get EEOC charges filed against their company. I'm starting to see EEOC charges filed. This is an example. Well, first of all, when you get an EEOC charge, and I know everyone considers them very seriously, but if you get one, you're going to get one more likely than not by an individual who claims that either he was laid off or permanently laid off because of, for example, his race and age, and the company started recalling or rehiring people, and he or she was not included because of his race or age. Well, you have a tendency to, and in my hypothetical, he was part of a plan or office-wide RIF across all departments. So you have to make a decision here. How do I respond to that EEOC charge? Because it's the first step in litigation. And what you respond to the EEOC with, you're going to be bound by if that employee or the EEOC files suit. When you get these charges and you think it's just a single plaintiff, single charging party making a claim, don't be fooled, because the EEOC investigations, they'll look at individual charges, but what they're really looking for a lot of times is a broader pattern and practice where more people in a protected characteristic were discriminated against. So you got to make a decision of how are you going to respond to these. These kind of, and so here's what happens. I get a charge, I see it, so I start looking at the entire reduction across an entire plant and all the employees and what their protected characteristics are and how widespread it is. I have to make a decision, how much of that do I go into? And up to this point, I have kept it very narrow. I've limited it only to that individual who filed the charge and waiting to see if the EEOC comes back looking for a pattern in practice. Okay, moving on to the second phase. How much time do I have? Ooh, I don't have much time. More reason to get this handout. This is the phase in terms of bringing people back, and it covers OSHA issues. It covers a lot of practical information from the CDC about returning people. It addresses ADA, Americans with Disability Accommodation requests, and some on litigation trends. Very quickly, OSHA requirements apply to preventing occupational exposure to COVID. If OSHA comes in and you have an employee who contracted COVID at work, they're going to assess your efforts in making your work-related determinations and what you did to prevent that. And was this COVID contracted at work? There are OSHA, in the OSHA materials, they provide presumptive indicators that COVID was contracted at work, and they provide presumptive indicators that COVID was not contracted at work. So might be worth your while to go on OSHA website and look at those. COVID-19 is considered to be a reportable illness. There are persons who are hospitalized as a result of COVID. If you make the determination, and again, the information's here on the website on how to try to do that, you have reporting obligations that are set in terms of time limits, just like any other occupational disease or injury, both in terms of non-fatalities and fatalities. Returning employees safely to work. EEOC permits a test that detects the presence of COVID-19 if it is job-related and consistent with business necessity. I'm not going to go over the Families First Coronavirus Response Act. I have information in the handout on that. All right, this is a question I get a lot of. And now I've moved on to accommodation requests or refusals to come back to work. I moved past the reductions in force at this point. This is just your normal everyday problem. Somebody says, I'm not going to come back to work because I'm afraid I'm going to get COVID. I follow the OSHA guidelines. The ADA and the other laws don't really apply to this unless you're discriminating against someone or you're failing to make accommodations. So I look to OSHA. And OSHA provides 4 instances when an employee can legitimately refuse to return to work. Those are in the materials. So if I have a client that calls me and says, Jane won't come back to work, she's afraid she has COVID, or she's afraid she'll contract COVID, what do I do? Well, unless all these 4 factors are triggered, I say, well, you can, she's no call, no show. She's refusing to come to work. Is she making an accommodation? Make sure and treat her consistently with everyone else. EEOC has specific guidance on COVID-19. A lot of what the EEOC does is they default to CDC guidances. The CDC has information on people who are at higher risk and not so high risk for COVID contraction anywhere, including at work. The accommodation process, I'm going to spend a couple minutes on this. I think everybody's probably familiar with the ADA accommodation process if a person is disabled. And I think a person that, depending upon the severity of the COVID infection, could meet the definition of a disability. There are no special EEOC or ADA accommodation rules for that type of person. So you treat that type of person like anyone else with an illness, an injury, or a disease. Pregnancy. The CDC does not specifically identify pregnancy as an underlying condition that puts an employee at higher risk, but says they might be at risk. Title VII, if you have a situation where a pregnant lady doesn't want to come back to work because she's afraid she's going to contract COVID, it's not an indicator under the CDC. So the question is, can you allow her not to come back to work? This assumes a lot of things. There's no leave requirement, so forth and so on, without running afoul of the discrimination laws. The Title VII says that women affected by pregnancy shall be treated the same for all employment-related purposes as other persons not so affected, but similar in their ability or inability to work. And I'm really moving fast because I suspect I'm out of time. Family members of employees are at higher risk of COVID. This is not an ADA issue. FMLA, remember with these COVID conditions, when the person may have a disability, you have the obligation to look at accommodations, and you are required to make reasonable accommodations unless it would create an undue hardship or burden. Am I out of time? I suspect I am.
I think if you have just a couple closing remarks or points you want to touch on, then we've got a few minutes for that.
No, I don't have anything. Any closing remarks? Let me think. Does anyone have any questions? I mean, I can go in deeper into this, and let me think here. Common questions I get. I'm still getting a lot of questions on reductions in force and layoffs and furloughs. So I know that has not gone away. I get a lot of questions on, I call them day questions, small issues about what should I do to make the workplace safer. That's covered in the CDC guidance. It's covered in this PowerPoint. I don't really have any closing questions, and I don't want to waste people's time. So if you're inclined to do so, get a copy of the presentation, and good luck to you.
Thank you so much, Mr. Gary. We appreciate you doing this for us. For everyone that's on here, if you're interested in getting the presentation, I believe that Teresa is going to post that or make some information available in the chat to be able to do that. And I think she'll be able to share the PowerPoint as well. So thank you. That is some great information. It's just, you know, like I said earlier, every day is a different day, and but it's good to have some information. I know for me, I've had to I've set in on several webinars, and having this type of PowerPoint to refer back to and to clarify questions is very helpful. So we really appreciate your help in providing that information, and so thank you. And we want to thank Walmart and Sam's Club again for sponsoring this, and for all of you for tuning in. Next week, on November 10th, our session will be legislative update with Mr. Roby Brock. So that'll be entertaining, and I guess next week we'll hopefully have some information about the election. And so that Roby should be able to provide some great information there. So anything else, Therese?
I do have one thing.
Okay.
And I guess this is lawyer, whatever. For your daily questions, don't feel like you always have to reach out to a lawyer and spend the money. I mean, that's fine to do, but a lot of these routine daily questions, just go on the internet and go to these federal government agency websites, and there's a wealth of information on there from A to Z on the guidance on how to handle these situations. Now, designing the RIF, recall issues, discrimination issues, that may be different. You may or may not be able to find the answers on the website, but there's a lot of information out there.
Super.
Sacrilege, attorney sacrilege, that's what I was trying to say.
Okay, so it looks like Therese has put her information out there in the chat group. So with that, I guess, Therese, do you have anything else to say?
We're good to go.
Okay, well, with that, we will end this. I wish everybody a great Tuesday. Go out and vote and enjoy your day. And thank you again, Jim. We appreciate you.
Bye.